Today, we're going to cover the legal rights of women and how it's changed over the centuries, particularly since common law and the increase of equal rights for women, at least delineated by law, but maybe not necessarily in theory or in practice. This chapter covers the status of women at common law, contracts and conveyances, the Married Women's Property Acts, equitable distribution, dower, courtesy, and elective share. Keep in mind that applies to common law states. Surname change at marriage and upon separation or divorce. Credit, employment, sexuality and reproductive rights, fetal homicide, violence against women, pro bono assistance in this area of law, and finally, client sensitivity when dealing with survivors of domestic violence. If you recall from previous chapters, at common law, women were very restricted in terms of rights. Arguably, they had no rights. Under the doctrine of coverture, her civil existence for many purposes merged with and was covered by that of her husband. At common law, a married woman was not able to make her own will. She couldn't own her own property. She couldn't make a contract in her own name. She could not sue. She also could not be sued, which would have discouraged merchants from dealing with her. This has all changed, particularly with Married Women's Property Acts. These are statutes that removed all or most of a woman's legal disabilities on matters such as entering contracts, disposing of her property, and being a party to litigation independent of her husband. Ultimately, the Married Women's Property Acts sought to abolish this doctrine or this idea that a married woman was covered by her husband and sought to abolish the doctrine of unity of the person that happened upon marriage. In recent weeks, we covered property division upon divorce in common law as well as community property states. Most courts use varying versions of equitable distribution, which is the just and fair, but not necessarily equal division of property between spouses upon divorce. If you recall, California is a community property state where both spouses are entitled to 50% of the marital property upon divorce or separation. In common law states, it's a little bit different. At common law, when a husband died, the surviving spouse was given the protection of dower, which was the right of a surviving wife to the lifetime use of 1/3 of all of the land her deceased husband owned during the marriage. If the wife died first, the husband's comparable right at common law was known as courtesy, his right to a life estate in all the land his wife owned during the marriage. There was an added provision for a husband to be entitled to courtesy, which was that he had to have had a child with the wife in order to be given the right to courtesy. Today, most states which follow the common law principles, not including California, again, have abolished dower and courtesy, and in its place, they give the surviving spouse an elective share of all of the property the deceased spouse owned at death. It's also known as a forced share because the surviving spouse can elect to take it in place of and in spite of what the will of the deceased spouse says the surviving spouse should receive. So an elective share is a percentage of a deceased spouse's estate that the surviving spouse can choose or elect to receive, despite what the will of the dead spouse provided for the surviving spouse. So they could choose either the will or they could choose their elective share. Again, this is what modern courts have now implemented in place of dower and courtesy, which of course were tied to the gender of it, being the spouse or the husband. And in the husband's case in courtesy, there had to also have been a child born during the marriage. In most states, there are two main ways that a person can legally change their name, their last name. Either the usage method, often known as the common law method, or the statutory method. The usage method simply involves just using a new surname. This new surname becomes the one's legal name without going through any court or agency procedure. The main requirement is that use of the name must be exclusive. They can only use one name at a time. Consistent, the new last name must be used for all purposes, and non-fraudulent. The new name is not used to avoid creditors or to help commit some other illegal act. Under the statutory method, this is a formal change of name procedure involving several steps. For example, filing a petition to change one's name in the appropriate state court, stating the reasons for the change, paying a fee to the court, and publishing a notice of the court proceeding in a local newspaper. This procedure, the statutory method, is usually not complicated as long as the court is convinced that the name change will not mislead anyone who may need to contact the individual, such as police officials, former spouses, of course, if they're trying to shield themselves from creditors. The main reason most people choose the statutory method is to have an official acknowledgement that the name change has been made, which is an important step in protecting oneself from identity theft. Of course, once the name is officially changed, it's the responsibility of the individual to notify DMV, their banks, insurance companies, their employer about the name change. California's statutory name change procedure is in the modules. Just on a personal note, I had to change my eldest son's last name. Initially, my husband wanted our oldest to have my last name, so we did when he was born, and then my husband had a change of heart and wanted my son to take his last name, probably 6 months, right just before his first birthday. So we had to go through the statutory method of changing my eldest son's last name from mine to my husband's. In terms of marriage, I kept my last name, so Hill is the last name I was born with. I did not take my husband's last name. But if you do recall, when you do get married, you're given the option upon your marriage certificate to change your last name then and there. If you don't do it at that point, you're going to have to go through the statutory name change method, which can be pretty cumbersome, particularly when you have to change your social security card, your passports. It can be also financial, a costly process as well to do so. Now, upon divorce, all courts will grant a mother's request that she be allowed to resume her maiden name or to use another name if she had taken her husband's surname upon the marriage. Now, what if a wife or a spouse or even a husband asks to change the name of the children of the marriage? Perhaps they want them to take the name of one of the other parents or the name of the new person that the ex-spouse will marry once the divorce is final. Unlike allowing spouses to return to their previous names, court will not automatically grant such requests for children. They'll want to be sure that the change would not harm the relationship between the child and the non-custodial father or mother, and that the change would be in the best interest of the child. So as we discussed in terms of child custody, in terms of changing names for children, the courts would have to do an assessment of the best interest of the child. The Federal Equal Credit Opportunity Act prohibits discrimination on the basis of sex or marital status in a credit application. So a creditor cannot discourage a woman from applying or reject her application because of her marital status. They cannot impose different terms or conditions, such as a higher interest rate or additional fees based on her sex or her marital status. I would encourage you to review pages 487 and 488 to review an extensive list of what creditors are not allowed to do in relation to a woman's gender or her marital status. Additionally, a woman has a right to have credit in her birth name, her first and her spouse's last name, or her first name and a combined last name. A woman can obtain credit without a cosigner if she meets the creditor's standards. She can also choose to have a cosigner other than her spouse if she legitimately needs a cosigner. A final note on credit before we move on to employment. The Federal Trade Commission stated that there are two major reasons that women don't have credit histories in their own names. Either they lost their credit histories when they married and changed their names, or creditors reported accounts shared by married couples in the husband's name only. So when dealing with clients, or even for your own knowledge, if you're married, separated, divorced, or widowed, be sure to contact your local credit reporting companies to make sure all relevant bill payments information is in a file under your own name. I personally subscribe to creditkarma.com. It's free. It'll email me whenever there's even just a slight change on my credit history or something has changed, my credit score has gone up, has gone down, or if there's something that looks fraudulent, it'll notify me right away. Just a great way to keep track of your credit. Okay, so we're now moving on to employment. An employment qualification based on gender, religion, or other characteristic that is reasonably necessary for the normal operation of a particular business and hence is not any legal requirement under federal employment discrimination laws is known as a BFOQ or a bona fide occupational qualification. Now, before we get into this, the Equal Protection Clause in the 14th Amendment, among other many federal laws, prohibit treating men and women differently unless this different treatment is substantially related to serve an important state interest. We talked about this in the very early stages of the class where we covered constitutional law. Gender is listed as a quasi-suspect class, calling for intermediate scrutiny. So again, if this disparate treatment between men and women based on gender cannot pass a test for intermediate scrutiny, meaning that it is not substantially related to serve an important state interest, it'll be struck down and deemed unconstitutional. Now, BFOQs are the exception, in which case a specific employment qualification requires a specific gender because it's reasonably necessary for the normal operation of this particular business. Now, some examples of BFOQs would include advertising agencies that hire only male models to model for men's clothes, theaters to hire only men to play father, sons, and uncles in a play. Another example is for a state prison to exclude women from being guards in all male prisons where a significant number of the inmates are convicted sex offenders. In that case, it's reasonable to anticipate that some of the inmates would attack the female guards, creating a security problem. Now, some examples that would not pass as BFOQs, it is not a BFOQ for a company to hire only women as bookkeepers because the boss wants to work with women. Gender has no relationship to being a bookkeeper. That is not substantially related to serve an important state interest. It's also not a BFOQ for an airline to hire only female flight attendants. Again, gender has no relationship to performing the job of a flight attendant. We dive a lot deeper into the interviewing process in the case management and communications class, but as a primer as it relates to women and gender discrimination, some potentially illegal employment interview questions to be aware of when engaging in an interview, either as an interviewer or interviewee. You simply cannot ask an applicant, are you married? What is your maiden name? Do you have any children? What kind of childcare arrangements do you have? Are you Miss or Mrs.? Questions that can be asked, however, are more broad and don't allude to marital status or gender or child rearing. An applicant can be asked, for example, what are your career objectives? Can you make a long-term commitment to the employer? Would you be available to work overtime? Do you have any restrictions that would prevent you from traveling? So these are open-ended questions that don't specifically ask about the woman's marital status, children, or her plans to have children, etc. Wage discrimination on the basis of sex can be a violation of Title VII of the 1964 Civil Rights Act. Equal Pay Act prohibits discrimination on the basis of sex in the payment of wages or benefits where men and women perform work with similar skill, effort, and responsibility for the same employer under similar working conditions. So it's widely known that women, on average, make 75 cents to the full dollar that a man would make in the same position. Now, although the Equal Pay Act and Title VII of the Civil Rights Act prohibits this discrimination on the basis of sex, some employers, of course, can circumvent this by saying it's really not based on gender, but instead based on education, training, experience requirements, so they can try to point to other factors besides sex to underscore their reasoning for paying the man more than the woman. But it is important to know that if you are, if you feel that you're being discriminated against, your client is facing discrimination based on sex, to file with the EEOC. Again, look in the modules. At least check out the website to see what the process is, what the forms look like, and just what the generalities are in terms of whether you think you or your client is facing discrimination in the workplace. So what about when a career woman is pregnant? An employer cannot refuse to hire a woman because of her pregnancy-related conditions, so long as she is able to perform the major functions necessary for the job. She cannot terminate workers because of pregnancy. I have a personal horror story related to this. When I was pregnant with my oldest, I was told by my employer, once I told her, she was also a woman, ironically, who had children, that she did not have any more work for me when she found out that I was pregnant. So it took me a while to really register that I was being discriminated against because of my pregnancy. But keep in mind, this is illegal, and you need to report the employer to the EEOC to file a discrimination claim. And you are entitled to unemployment benefits in this situation, which I had to fight for, but also ultimately received. So yeah, pregnancy in the workplace is a very touchy subject. You don't think you may think it might not happen to you, but there you go. You end up being discriminated against, and it could be by a woman, ironically. So it's important to know your rights, know your client's rights as they relate to pregnancy in the workplace. I also included a California Senate bill in the modules that expands lactation accommodations for women who are expressing milk in the workplace. I also was discriminated in that situation as well. So in my second pregnancy, I knew my rights in terms of being able to use my breaks to express milk up until my child was 1 year old. And I was the subject of gossiping. I could not focus and express my milk because I could hear my coworker spreading rumors, calling me a cow, milking myself, just generally harassing me, trying to accuse me of using my breaks to express milk as an excuse to just not work and be lazy. So be sure to know the lactation accommodations, that they are available to you, especially if you work for a larger employer. You also aren't forced to go into a broom closet to express milk. You'd be pleased to read the lactation accommodation Senate bill, which would require employers to also provide mini fridges, a comfortable space for a woman to express milk for her child. The good news is that this is becoming more widely accepted. There's a lot of male proponents who advocate for women to be able to utilize their lactation accommodations and assert their rights as it relates to expressing milk for their children. So we are seeing a trend towards a wide acceptance for women being able to feed their children in the workplace. We're now moving on to sexual harassment. Sexual harassment is unwanted and offensive sexual advances, contact, comments, or other interaction. On the job, there are two categories of sexual harassment that constitute an unlawful employment practice under Title VII of the Civil Rights Act. Quid pro quo sexual harassment is submission to or rejection of unwelcome sexual conduct used as a basis for employment decisions on promotion for other job-related benefits. So, for example, a worker who is fired for refusing to become sexually intimate with a supervisor would be an example of quid pro quo sexual harassment. The other form of sexual harassment is hostile environment sexual harassment. This is pervasive, unwelcome sexual conduct or sex-based ridicule that unreasonably interferes with an individual's job performance or that creates an intimidating, hostile, or offensive working environment, even if no tangible or economic consequences result. An example of hostile environment is an office or other workplace that is pervaded by people telling inappropriate jokes, displaying obscene pictures, making graphic comments about the bodies of other persons, touching themselves sexually in the presence of others, persistently asking for dates, etc. Also keep in mind that harassment does not have to be of a sexual nature. It can include offensive remarks about a person's sex. So for example, it's illegal to harass a woman by making offensive comments about women in general. Both victim and the harasser can be either a woman or a man, and the victim and harasser can be the same sex as well. There isn't a specific relationship that needs to exist between the two parties. The harasser can be either the victim supervisor, a supervisor in another area, a coworker, or even someone who's not an employee of the employer, such as a client or a customer. Before we move on, I just wanted to note that it's not enough that an employer has to release a written statement saying sexual harassment is prohibited in the workplace. They have to work to actively combat sexual harassment in the workplace. So not only do they have to establish a written policy against sexual harassment and ensure that everyone in the office has received it, they need to actively investigate all accusations of sexual harassment promptly and also establish appropriate sanctions for employees who commit sexual harassment, inform employees of their rights to raise a charge of sexual harassment under Title VII, and also inform employees how to assert a complaint of sexual harassment under Title VII. So an employer can't defend themselves saying they didn't know one of their employees engaged in sexual harassment if it took place in spite of if it took place and the employer should have known of the harassing conduct. We've heard many stories lately in Hollywood, in USA Gymnastics, and other well-known organizations in which case the employer should have known but failed to take it, or they didn't know but they would have known. And in some worst cases, they actually did know of this inappropriate conduct, but failed to take any action at all, or immediate action, again, which has to be more than just telling employees to stop it. They have to actually actively work to combat the harassment, investigate all of the claims promptly and efficiently, and alert the necessary officials in an appropriate time frame. Okay, we're now moving on to contraception and birth control. Both married and unmarried individuals cannot be denied access to contraceptives. The decision on whether to procreate is a fundamental right and part of the individual's constitutional right to privacy, which we've discussed previously, particularly in Lawrence v. Texas. Contraception falls within an individual's fundamental right to privacy and decision whether or not to procreate. A state cannot place undue burdens on a woman's right to an abortion before viability. So while a state can encourage women to choose childbirth over abortion, they cannot prevent substantial obstacles in the path of her decision to abort a non-viable fetus, also known as the Casey test. So under this undue burden test, it is not an undue burden on the right to abortion for a state to require, unless it's a medical emergency, that at least 24 hours before performing an abortion, a physician give a woman information about the nature of the procedure, the health risks of abortion and of childbirth, the probable gestational age of her unborn child, available medical assistance for childbirth, methods of obtaining child support from the father, and a list of agencies that provide adoption and other services as alternatives to abortion. Providing this information is not a substantial obstacle because this information allows women to give informed consent to whatever decision they choose to make. So that would not be an undue burden. Now, it would be an undue burden, for example, on the right to abortion for a state to require a signed statement from the woman that she has notified her spouse that she is about to undergo an abortion. Now, this is a substantial obstacle because many women may not seek an abortion due to a fear of psychological or physical abuse from their husband. This also assumes that they have a husband. Furthermore, a woman doesn't need her husband's consent to undergo an abortion. He doesn't have a veto. He doesn't really have a say. So therefore, notifying him about the planned abortion is not necessary and would be a substantial obstacle in the path of her decision. So we just briefly mentioned domestic violence. Domestic violence is actual or threatened injury or abuse by one member of a family or household on another member. A DV can be committed against a spouse, children, same-sex partners, and in some states against a dating partner as well. Some of the issues surrounding domestic violence cases is when the victim doesn't want to either appear in court or make an arrest or even make a complaint out of fear or whatever the reasoning may be. As a response to this, mandatory arrest, prosecution, and mandatory prosecution have been implemented to kind of circumvent relying on the victim to come forward and either call for the arrest or decide to press charges and prosecute. Under the mandatory arrest law, this requires the police to make an arrest if there's probable cause that exists that a crime has been committed, regardless of whether or not the victim wishes that the batterer or the defendant be arrested. Under mandatory prosecution, government attorneys are required to bring criminal charges against batterers even if the victim refuses to cooperate or wants to drop charges for whatever reasoning, out of fear or change of heart, whatever it may be. So again, mandatory arrest laws and mandatory prosecution are ways that the government has circumvented relying on the victim to come forward and placing the burden on the victim to either mandate arrest or decide to prosecute. So what are the defendant's rights in this situation? The Confrontation Clause of the U.S. Constitution prohibits the use of testimonial statements made by an alleged victim who now refuses to cooperate in the case against an alleged batterer. The use of non-testimonial statements is allowed, however. So again, if it's a testimonial statement, the Confrontation Clause is violated by its use when the maker of the statement is not available for cross-examination. If it's a non-testimonial statement, the Confrontation Clause is not violated by its use when the maker of the statement is not available for cross-examination. So an example of statements that are non-testimonial are those which are made in the course of police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. So the typical non-testimonial statement would be a panicked 911 call as the emergency is ongoing. On the other hand, a statement would become testimonial once there is no longer an ongoing emergency, and the primary purpose of the interrogation is to establish or prove past events potentially relevant to later criminal prosecution. So let's say the abuse, the emergency has already taken place, the police arrive on the scene and then decide to take the victim's statement. At that point, that would be considered a testimonial statement, which would not be allowed in court. If you are interested in this, in evidence procedures, I'd highly recommend that you take evidence law. It can be very interesting to see the distinctions between what is admissible in court and what is not. So again, 911 panicked calls during an ongoing emergency would be allowed in court, whereas after the emergency has already taken place and a witness or a victim statement is being taken, that would be considered testimonial and would not be admissible in court. Some women have taken the extreme step of killing the husband or other intimate partner who have been abusing them. I don't know if some of you have heard about the Cyntoia Brown case, in which case a teenager had killed, she was pimped out by her her abusive boyfriend, and she ended up killing somebody who had picked her up at the side of the road, kind of reminiscent of the movie Monster as well. In this situation of killing or murder, a woman might try to assert battered women syndrome as a supplement to the self-defense argument. Battered women syndrome is a woman's psychological helplessness or paralysis because of conditions such as financial dependence, loneliness, guilt, shame, and fear of reprisal from her boyfriend or husband who has repeatedly subjected her to physical, sexual, or emotional abuse in the past. So it's not a separate defense, but could likely be raised by the defense as part of a self-defense argument. So keep in mind that in order to raise the traditional defense of self-defense, a citizen can use deadly force that they reasonably believe is necessary to protect themselves from imminent death or serious bodily injury. So imminent death or imminent is near, at hand, coming soon, about to happen, immediate. So under the battered women syndrome, a defendant, typically a woman, who kills her batterer will assert that this is still part of self-defense by widening the definition of imminent. So perhaps in a situation where a woman kills her abusive husband who's abused her for years repeatedly while he's sleeping, in that case, she arguably cannot raise a self-defense argument because he's asleep. He's not about to hurt her or harm her immediately. But by asserting battered women syndrome, she could say that imminence is everyday life for her. It's a cycle. It's a cycle of violence that she's constantly in imminent danger, regardless of whether he's asleep or whether he's about to strike her then and there. So it really depends on the court, but this is an argument that defense can and will likely raise for victims of domestic violence as a means to strengthen their self-defense argument. Now, can a spouse rape their spouse? Yes. Marital rape is not a crime in every state, but most states do allow prosecution if the parties are separated and a petition has been filed for divorce or separate maintenance. Most criminal penal codes that delineate rape or define rape do not provide an exception for marital rape. Rape is rape regardless of who the parties are involved. So again, common law, in which case a woman cannot rape herself, or a man cannot rape his wife because ultimately he would be raping himself, is an unfounded argument. And as we've seen with the evolution of legal rights for women, husbands or even wives can still be accused of marital rape and guilty of marital rape if it's a crime in that state. Okay, that concludes our chapter on the legal rights of women. Thank you for listening.